What is the difference between Petit and Grand Larceny in New York? Larceny, as defined under New York law, refers to depriving someone of their property. This broad definition encompasses money, possessions, and even personal data. The law classifies larceny as either petit or grand, with significant differences in the severity of the charges and penalties associated with each. Petit larceny is a Class A misdemeanor involving theft of property valued at $1,000 or less. Grand larceny, on the other hand, applies when the stolen property exceeds $1,000 in value or involves specific types of property, such as motor vehicles, firearms, or credit cards, regardless of their monetary value. Understanding these classifications is essential because the penalties can range from community service for petit larceny to lengthy prison terms for grand larceny. Consulting with an experienced attorney is crucial to navigate these charges effectively. The legal distinctions of petit and grand larceny in New York. Petit larceny represents the simplest form of theft, carrying a maximum sentence of 1 year in jail. Grand larceny, however, is classified into 4 degrees based on the value of the stolen property or its type. 4th degree grand larceny, Class E felony, theft exceeding $1,000, punishable by up to 4 years in prison. 3rd degree grand larceny, Class D felony, theft exceeding $3,000, punishable by up to 7 years in prison. 2nd degree grand larceny, Class C felony, theft exceeding $50,000, punishable by up to 15 years in prison. 1st degree grand larceny, Class B felony, theft exceeding $1 million, punishable by up to 25 years in prison. Legal outcomes for both crimes can vary, with alternatives like probation or community service available in some cases. However, individuals with prior convictions may face mandatory sentencing. A skilled lawyer can help determine the best strategy based on the unique circumstances of the case. How larceny cases are processed in New York. When charged with larceny, the value of the stolen property is critical. This value is typically determined by the market value at the time of the crime, and disputes over valuation can significantly affect the charges. For instance, if the exact value is unclear, the law allows a default value of $250. Both petit and grand larceny charges are considered crimes of moral turpitude, carrying lasting consequences for the individual's reputation and future. Sentencing is also impacted by accompanying charges, such as criminal possession of stolen property. For example, possession of goods worth less than $1,000 aligns with penalties for petit larceny, while possession exceeding $1,000 can escalate the charge to a Class E felony. The complexities of these cases underscore the importance of representation by a qualified attorney. If you're facing petit or grand larceny charges, protect your future by contacting the law offices of Jason Bassett, PC at 320 Carleton Avenue, number 4200, Central Islip, New York, 11722. Call us today at 631-259-6060 to schedule a consultation with an experienced criminal defense lawyer.